You are a homeowner who's a victim of Pink Energy, the solar company, then our law firm wants to talk to you. I'm Kevin Kneupper. I'm an attorney at the law firm of Kneupper Covey, and we are investigating and preparing for a mass arbitration against the financial companies that lent people money for botched solar installations as part of Pink Energy's business. And this is a company that's gone into bankruptcy. If you don't know who they are, you are very fortunate. If you do know who they are, then you may be one of these homeowners who has had their lives kind of upended because of this bankruptcy that occurred while a bunch of state attorney generals were investigating Pink Energy, which used to be called PowerHome Solar, for deceptive practices that they were doing, allegedly doing, while installing solar panels and selling solar panels to people for their homes. Now, the people who have these solar panels are in a real quandary because they are stuck there with solar panels, and the company that sold them is now bankrupt. And what does a bankruptcy do? It immediately imposes what's called a stay or a pause on any litigation against Pink Energy itself. So the homeowners are completely in a bind. They can't sue Pink Energy because of this bankruptcy. Doesn't really look like there's enough assets to go around. Pink Energy is the bankruptcy trustee is working to sue a company called Generac that was the one selling some of the battery related parts to this that Pink Energy is pointing the finger at for a lot of the power generation issues that were happening. So what are you supposed to do if you're a homeowner? Because a lot of the financing companies, an example would be Good Leap is one of them, Mosaic, Sunlight Financial. They are asking people to just keep making payments. In some cases, they're arranging, or trying to arrange for maintenance or whatever from other companies, but there are homeowners reporting that they've just been told to kind of pound sand and just keep making your payment because that's not my problem. I'm the financing company. What are you going to do about it? And there's varying results from different financing companies. We're hearing different things about different ones. But we are looking to talk to anyone who has Pink Energy solar panels and is not having them maintained, or who was deceived as part of the sales process, or who doesn't think that they should be paying on the solar panels because of some issue that went on, with them. And really, for anyone who has this, they had maintenance contracts. They had contracts to service these panels, and the company that was supposed to do that is now bankrupt. So why should you still be paying for your solar panels? Our law firm believes that something called the FTC Holder Rule, that is the Federal Trade Commission, an agency that regulates protection of consumers. The FTC Holder Rule is a legal rule that we think imposes liability on the financing companies in this situation. And we have taken on several claims already from several consumers, and we are looking to take on more because we think those financing companies are very clearly liable for any claims that could be made against Pink Energy up to a certain amount. There's limits on it under the rule. So it's not a kind of you're going to get rich type thing, but it could get you out of having to make payments on solar panels that aren't being maintained like they're supposed to be. Now, if you don't know what Pink Energy is, I want to walk you through one of the Attorney General letters that shows why everyone's so mad about this in the first place before even the bankruptcy started, and what the Attorney Generals are at least asking from these financial companies. And what you're looking at here, you can see at the top that it's listed as this is a letter, and it's to 5 different financing companies. And importantly, that I'll talk about in a minute, 3 of these are located in California: Good Leap, Dividend Solar Finance, and Solar Mosaic Inc. That's where they're headquartered. This comes from, it's on the letterhead of the Office of the Attorney General for the state of Kentucky. An attorney general is just like the chief sort of attorney for any given state. They'll almost always have an attorney general who is this person who kind of sues to protect people in their state. And if you look at the bottom, it's not just the attorney general of Kentucky. They've got North Carolina, they've got Illinois, Indiana, Michigan, Pennsylvania, South Carolina, Tennessee, Virginia. These 9 different state attorney generals all had been investigating Pink Energy for deceptive practices with respect to consumers. And they all, after the bankruptcy was filed, sent a letter to these lenders saying, hey, you should stop billing the customers here because what happened is not fair. You can see they say, as you're likely aware, on October 7th, 2022, Pink Energy, which is also PowerHome Solar, filed for bankruptcy, and they'd been under investigation and or litigation by the undersigned attorneys general for suspected violations of our respective states' consumer protections laws, as well as applicable federal statutes and regulations. And they say the purpose of this letter is to request that your companies provide relief to our consumers. And then they give background on what's being alleged about what happened to Pink Energy. And you may have had, if you're someone who had a Pink Energy or a PowerHome Solar installation, you may have had different scenarios happen. The solar energy industry is really kind of junky in a lot of respects. There are some shady salespeople who lie to people. We've seen cases in our practice of allegations of very elderly people having their signatures forged through iPads, where the person just sort of signs on the iPad. And sometimes you can look at the data on that and tell when the signature occurred, and it was happening basically instantaneously with the other signature from the like basically without anything having been possible to look at. If you sign a document after opening it up, 1 second later, you have not looked at the document. But this says that here's some of the allegations that they're saying happened with Pink Energy, these attorney generals, that there was complaints that the systems do not provide anywhere near the level of energy savings promised. Many consumers have solar power systems that have repeatedly malfunctioned, or not functioning at all, or not certified by the local electric utility to transmit electricity to the grid. Those consumers were led to believe that they were making an environmentally friendly and financially prudent decision by purchasing a solar power system from Pink, and are now stuck making loan payments for an underperforming or non-functioning solar power system on top of their monthly electric bill. And they also said that there have been complaints that Pink Energy misrepresented the availability of state or federal tax credits, and then the consumers ended up paying a bunch more money because they didn't realize that they weren't actually going to get these tax credits, or not at the same amount that they were promised, and that it's even worse because if the solar power system isn't functioning at all, or not functioning properly, then you're not getting the savings that you were promised, and you're not able, you're being sold one thing and not getting what you thought you would get. That's a misrepresentation when something like that happens. So what do you do if you're one of these consumers and Pink Energy's bankrupt, and now you sort of are like, I'm stuck? Are you really stuck? And I think a lot of people thought they were stuck. A lot of people have had trouble getting attorneys. I know we've kind of looked around at people talking about this online. There's Facebook groups. There's people who have this problem, are trying to figure it out, and they're getting quotes from attorneys for large amounts of money. So can you? What can you do? I will say, to start off, I don't think that you can sue Pink Energy right now because of the bankruptcy stay. The stay pauses things. The point of this sort of pause is the idea that people shouldn't go pick apart the carcass of the company in a uneven and sort of unorganized process. So the bankruptcy court wants to keep that process orderly, make sure everyone gets a fair share of what's left. And if you have everyone just trying to sue Pink Energy, then the amount of money gets grabbed. It's whoever gets it first. If everyone's just allowed to sort of sue and go at them. And so trying to sue the company itself, I'm not sure works. I don't think it works. Trying to sue the financial companies is a very different story. I want to talk to you all a little bit about what happens with that. Now, you'll notice that one of the things that I flagged is that 3 of those financing companies are headquartered and based out of California. That's really important for a couple of reasons. One is that I'm licensed in California and the state of Texas only, so those are the only states that I could go do a lawsuit in without. There's certain procedures that you can sometimes do, partnering with local attorneys, or something called pro hoc vice, where you can work on one case for or a limited number of cases in another state that you're not licensed in. But because I'm licensed in California, and my law partner, Kevin Covey, which is his real name, is also licensed in California. We also have one other attorney presently, as of the date of this video, Lorraine Weeks, who is licensed in California. And that means that we can practice and do arbitrations there. So if you are suing someone in the state of California, then we can represent you in a lawsuit or an arbitration in California itself. Now, because those companies are located here, that's sort of the natural place to sue them, because that's where there would be jurisdiction for those 3 financing companies. For the other ones, we would have to look at there's possibility we could partner with local attorneys to be able to do that. That's something that we'd have to discuss separately. We're happy to talk to you about it if you have one of those other companies. But definitely companies like GoodLeap, we are already taking on clients on GoodLeap in California. And that's because we think that California's laws are extremely protective of consumers. California has something called, or they have various laws that basically are much stronger in many cases than other states, in my opinion. And I think that's kind of generally accepted, that California just is, in general, has better laws, not than every state, but than a lot of them. And the key factor to all this, and what we like about these cases and why we are interested in taking them on, is because of this FTC Holder Rule, and also because of how the state of California and its Supreme Court has interpreted the FTC Holder Rule. I want to talk to you a little bit about that, and a little bit about how this process works if you're interested in talking to our firm about it. Thing you're probably interested, before getting into the law, I guess, is sort of what attorneys charge on this and how we do the fee structure. Because I know when I've seen people online talking about this in forums, they've been concerned that the attorneys are asking for amounts that are so much that you couldn't. I mean, it might be a lot. I'll just say a lot if you're paying the attorney yourself. So our firm is willing to do contingent fees on this case. If you don't know what a contingent fee means, it means that the attorneys uh, would take a percentage of the recovery, and that's outlined in detail in the engagement letter, which is a contract with the attorneys. A contingent fee basically means, like, at the very simplest level, that you are paying that percentage. It does include, on top of that percentage would be costs. What are costs? Costs are things like, they're basically like expenses that of doing the litigation. And so, if it's an arbitration, just an example, if you don't know what an arbitration is, it's kind of a simplified version of a lawsuit that is done in private. And in a lot of the financing agreements, they include this. I know the Good Leap ones we've seen have arbitration clauses, which means most of those would probably be done in arbitration. Um, in arbitration, one of the key costs is there's a 250, like, for just an example, this is JAMS, is the name of one of the arbitration associations. They make the consumer pay $250 as the filing fee, and the business has to pay all the rest of the fees for the arbitration. That $250 would be a cost. That's something where our firm would advance that, so we would pay it. If we lose, you would not pay the $250 or the cost, and you wouldn't pay any of the costs if we lose at an arbitration. But if there's a settlement uh, or if you go to the end of the arbitration, then the costs are something that the would come out of the recovery on top of the contingent, which would be the percentage. And those in an arbitration, I would say generally they're not that much. In litigation, there can be other things that are costs. For example, there are expert witnesses. Usually, if you go to a lawsuit, we've had some solar energy cases where we've used experts. Just to give you a ballpark idea of what those costs have been, it's for an arbitration, they've been in the range of around $1,000 and sometimes less. If you're having someone inspect the house, it could be more. I'm not promising that that's the only amount that something could ever be. Or some people have roof damage and need, like, one of the things we've looked at or done is had like drones fly over the house to do like or there's varying ways that you can do that. But basically, you're doing like a trying to find a leak in the roof with like a heat sensing type thing. They can do it with drones. You can do it with just photographs. You can do it with various other methods. But those can be, I've seen estimates for those, or we've had estimates in $1,000 or so range as well. But those would be things that would be examples of things that would be costs. And so, um, in general, part of why we like this and we like these FTC holder rules that I'll get cases in, that I'll get to in a minute, is that if you win one of these arbitrations, there are fee and cost shifting provisions, is what they're called, that make the business pay your costs and attorney's fees as part of the award, and that's up to the arbitrator or to a judge. That generally is what happens, and um, you can't predict 100% what's going to happen, because ultimately those decisions, it depends on if you win your case. It depends on a lot of different factors, but that is something that makes it much more interesting as an attorney to take the cases, and which is why we're willing to do them on a basis. So let me walk you through what next. You have a question of sort of what was I referencing when I was talking about a mass arbitration? What is that like? And why is it something that you'd want to be a part of? So mass arbitrations are something, if you've heard of class actions, so you can probably, a lot of people have heard of class actions from movies, from TV shows. A class action, it's kind of been on the decline in recent years because of this arbitration stuff. Like, arbitration is in most contracts now with companies. Class actions are when you have sort of one or two people or some small group of people come in, they do a lawsuit, they represent a large group of people. And so you would have, if there were a class action, you would have a few people come in and sue on behalf of everyone, and then the court would set amounts of money that go to everyone if you win. And it's a whole sort of separate process, but it works like a lawsuit, and it is a lawsuit. Um, uh, Arbitration clauses are things that companies have begun putting in agreements that take away your right to do a lawsuit, and often they have what's called a class waiver, which takes away your right to do a class action specifically. Those are generally have been held enforceable by the Supreme Court. Not always. There are ways around them sometimes, but in general, it is much harder to do a class action when those clauses are in the contract. What attorneys like us have started doing instead is mass arbitrations. Mass arbitration is where, instead of getting two or three people to go do a lawsuit, in a case like Pink Energy, I think there is looking like tens of thousands of people have been affected by this. You just go get as many of them as you can, or who want to participate, and just each file separate arbitrations. And so we pay the $250 fee, you get as many of them as you can. We're doing one of these right now with a company called Vroom, which is a online car sales company. We have several hundred people that we're representing in connection with that mass arbitration. And you you basically are using the weight of it together to try to force settlement and to try to get everyone the best deal possible. So everyone is filing, they're all separate. You have your own, like it is your arbitration. So whatever you want to do in terms of your own settlement, unlike a class action, in a class action, sort of it's like one agreed settlement for everyone. In a mass arbitration, you always have the right to make your own decisions about your settlement. But there is more pressure on the companies to do something when you have that many people. It becomes very hard for them to fight them all. It's like a swarm of birds sort of pecking them to death, I guess is maybe the way to put it. Versus a class action where you've got Godzilla coming in trying to fight them. Well, I don't know how those analogies work, but it is very much like that. And you can create the pressure with a lot of little cases to have them kind of like trying to handle that is logistically a very difficult thing for defendants, and the costs of them trying to do it are a lot as well. And so um, and we get settlements. That's just something that you have to see as we go forward. There's no promises about what can happen, but it is something where we like the legal claims and we think that they're good. And why do we like the legal claims? I want to just walk you through kind of what this FTC holder rule is and why we think if you had a good claim against Pink Energy, then you would also have a good claim against the financing company up to a certain amount. What I'm showing you here is this legal decision from the Supreme Court of California. I'm showing you that not just because it's from California, which is where we're looking at doing these arbitrations, but also because it's a case that it's kind of it gives a pretty good explanation of like what the FTC holder rule is and why the Federal Trade Commission adopted this in the first place, and why would you be able to sue the financing company? And there was sort of a decision as a matter of policy that you because of these fly by night, sometimes there are fly by night operations, right? And the fly by night is just someone who just sets up an office, and in the context of solar, they would install a bunch of panels and then they just close the office and they're gone. And what are you going to do? And they in the 1970s, there had been problems with this that in sort of various other sectors, particularly automobile type dealerships and stuff like that, where people would borrow large amounts of money, and then the financing companies would say, "Sorry, that's not my problem." And the Federal Trade Commission made this rule that kind of said, "Look, who's the best between the consumer, the regular person, or this financing company that's doing a lot of transactions with seller? Who really should bear the risk on this, and who should be responsible if it goes wrong, and if the seller that you're dealing with just goes bankrupt or disappears or whatever? Should you be responsible for all that, or should the financing company?" Let's look a little bit at the background of this FTC holder rule. You can see this opinion says right here. It says what I was just saying. It says that the Federal Trade Commission promulgated, that means they passed the holder rule in 1975 in response to rapid growth in consumer installment debt in the United States. Before the holder rule, a third party who purchased a consumer's promissory note, that's the debt, did so free and clear of any claim or grievance that the consumer may have with respect to the seller. This holder in due course rule meant that a creditor, that'd be someone like one of these financing companies for the solar panels, could seek payment from a buyer on goods never delivered or not delivered as promised, while remaining immune from the buyer's claims of fraud, misrepresentation, or breach of contract or warranty against the seller. So before this FTC holder rule existed, there was this problem where you're using solar panels as the example. Someone could just sell you a solar panel, not ever deliver it or not deliver it working. And then the person who lent you the money for it could just be like, sorry, you're paying me. I don't really care. And there's nothing you could do. And so the Federal Trade Commission did not like that. They said that consumers are not in an equivalent position to commercial entities to vindicate their rights against a payee. That's the company that, is kind of, I guess in this case, the seller of the solar panels, which would be Pink Energy. Between an innocent consumer whose dealings with an unreliable seller are at most episodic and a finance institution qualifying as a holder in due course, the financer is in a better position both to protect itself and to assume the risk of a seller's reliability. The FTC recognized that creditors and sellers are in a position to engage in meaningful arm's length bargaining, which differentiates them from buyers who sign adhesion contracts with sellers. Allocating the costs of seller misconduct to the creditor makes it much more likely that the market will be policed of unscrupulous merchants, that the market will reflect a more accurate price for consumer goods, and that all parties will benefit accordingly. So what is this saying? This is saying that the Federal Trade Commission had confronted the same problem that y'all are confronting right now. If you're a Pink Energy buyer, this is your problem, right? Is that nobody was policing Pink Energy correctly. And what the Federal Trade Commission said is that the fair thing to do, the just thing to do, and the right thing to do is, and for everybody, is to put some of this risk on the financing companies. if they have some of this risk, they are in a better position than you, just like a random consumer who only deals with this solar company once. Who is in the better position here? If you start asking yourself, who is in a better position to deal with Pink Energy and to make sure that they actually follow through on consumers? The lenders are the ones who dealt with them for large amounts of money here. I mean, you think how much your solar panel contract cost, and then multiply that by tens of thousands of people. Those lenders did, they did repeated transactions. And so who's in a better position to allocate the risk? Who is in a better position to pressure Pink Energy to do things the right way? And that's why you made this rule, or the FTC made this rule. When you have this rule, the lenders have some skin in the game, and they do have skin in the game, and that's the thing that they may not tell you they do, or people may not, you as a consumer may not think they do. But this is what the law is saying: is that the federal, the FTC Holder Rule. Our belief about this law is that it gives you rights to pursue claims, and you may even see something in your contract on that. You may even see because the FTC Holder Rule requires provisions to be included in the contract, and whether they put it in there or not, it's still enforceable. But you may see something in your contract that literally says there's an FTC Holder Rule if you dig deep enough down in there. What else does this California Supreme Court opinion say? It says, and this is what that says. It says, to effect this allocation, the Holder Rule requires the following notice appear in consumer credit contracts. And what this is quoting here is this notice that's supposed to be in a contract for consumer credit. That says, any holder of this consumer credit contract is subject, the holder being, in this case, the financing companies, is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained pursuant hereto or with the proceeds hereof. Okay, so what is that saying? It's saying that the person who holds the debt, that's the financing company, it's whoever buys the debt, whoever is trying to collect money from the consumer, is subject to all the claims and defenses which you, the person who has the solar panel system, could assert against the seller of the goods and services, that's Pink Energy, that were obtained with the proceeds of the loan. So if some company lends money to you to buy a solar panel system to install, and then that money's going, being obtained from with that money, or that a system is being obtained with that money, then you can bring any claims that you would have had or defenses that you would have had against Pink Energy against the person who holds this debt and or a company that holds this debt and who is trying to collect money from you on it. So we are not really in a situation where I don't believe, where y'all are stuck having to pay money on these debts when you have legal claims against Pink Energy. You can just make those claims against these financing companies, which are not in bankruptcy. This says, here's one thing that's very important too for you to understand about what your rights are, because you want to make clear when I've said there may be some limits on this. It says recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. So there are limitations on this, and what that basically means is that you're not going to be getting, let's say you have a $300,000 claim against Pink Energy, but your debt's only for $50,000. You can't get the whole $300,000. There can be a cap based on the amount that you're sort of obligated to pay, the amount that there's law on this sort of about being able to cancel the debt, or the amount that you paid, $200 a month for 2 years or whatever. But you're not going to be getting a windfall, but you could be limiting or canceling. Like, that's all dependent on kind of what happens with the law, what the arbitrator thinks and interprets the law. But we believe that will place limits on the amount that you have to pay, and it depends how much you may have been damaged. So there's all kind of factors that can affect that. But you do need to understand that there is a cap, so that if, like, let's say Pink Energy, the best example of this for this particular situation where you may have consumers who have debt that, like rather a legal claim that's more than the debt, is like, let's say Pink Energy caved your roof in and did damage to your house, because that has happened to some people with some solar companies. They damaged the house. The damage, like if you're in California, for example, those houses could be $2 million and could be way more expensive than the solar panel system was. You unfortunately will not be able to go to the financing company and go get just an unlimited amount of money. But there is not a limit. This California Supreme Court case is saying there is not a limitation on your attorney's fees. And that's a key factor to allowing this to be a contingent fee case, because even if you're it means that even if you are only recovering a small amount if there is a fee shifting statute that covers it, that makes the business pay the fees of the consumer. In California, there are a lot of those. There are a lot of ways that can be, that we can get to that. We believe, then there are no caps on sort of the amount of the fees. So even if the lawsuit is costing, the reason they have those is because, and probably what you've experienced if you tried to hire a lawyer, you may have seen estimates that are very high, and that you can't pay. And the reason is they may exceed the cost of like the solar panel system if the attorney's just working by the hour. That's why they have these laws in the first place. And this opinion even talks about that a little more. So just so you don't have to sort of take my word for it, you can look at what the California Supreme Court said about the whole sort of policy. Like why did they make these policies? Why did they have these fee shifting laws in the first place? You can see that there is a little discussion in this opinion because that's kind of what the core of this California opinion was about. And this is only binding in California under state law, but it's something that just explains to you sort of the logic, I think, behind what the Federal Trade Commission was doing. It says that the FTC recognized that the problems associated with the holder in due course doctrine, that's kind of the old rule where you were out of luck, are most keenly felt by the poor in our society. Consider the challenges, including high legal costs for consumers associated with bringing suits against sellers as an impetus to adopting the new rule. Impetus just means the reason that's making you adopt this new FTC holder rule. Aggrieved consumers are often not in a position to take advantage of the legal system where seller misconduct in a credit sale transaction has given rise to consumer injury. The consumer is theoretically in a position to seek damages or other relief from the seller in court. The amount of a consumer's damages in such a case may be substantial in real terms, but such damages are rarely enough to attract competent representation. Means a lawyer who's good. The sheer costs of recourse to the legal system to vindicate a small claim, together with the days of work that must be missed in order to prosecute such a claim to judgment, render recourse to the legal system uneconomic. And that means that basically it costs a lot more to go sue the person than it does that you would ever get from your solar panels. And I think that's definitely true today if you didn't have this rule. And it says, in addition, the worst sellers are likely to be the most volatile entities where market tenure is concerned. They prove difficult to locate and serve, and the marginal liquidity which characterizes their operations makes collection of a judgment difficult or impossible, even if they are successfully served. Bankruptcy or insolvency becomes a final barrier to recovery. And I'm sure anyone who has a pink energy system is very familiar with that right now. So this is the sort of the whole point of this rule and the whole point of many consumer protection statutes. There's lots of warranty laws. There's a warranty law called Magnuson Moss that we use or have been using in the good leap cases that we filed so far. There are just really a number of consumer protection statutes that can help you and a number of different laws that we think that we can try to have a recovery here. So in general, this is something where we want to talk to anyone who has a pink energy case. So if you bought pink energy and you want to talk to us, we're happy to talk to anybody. And the best way to get a hold of us, there's a phone number. I'm going to be putting it up on the screen. Then I'm also going to, if you look at the header on my profile, like literally just click on my YouTube profile, there's a phone number there you could call. That's the best way to get a hold of us. It'll take you to an intake system. We do get flooded with calls, I will say that we get a lot of calls, like you cannot believe. But this is a case we're focusing on because we think it's something where it is very severe sort of wrong that's going on right now, and where we think we can do these cases pretty efficiently. So we are prioritizing cases. If you call the number, minimum you will get to a survey, and that is it basically is like a text message survey. You fill it out, it's in like flag Pink Energy is the company that you're or like if you have one of the financing companies, let us know which financing company you have, and then our intake team will get back to you about basically getting documents and getting information from you that would let us evaluate your claim and whether we can take it. And we'd love to talk to anyone who's in this situation because we really think that these consumers are being treated pretty unfairly, where you get sold something you think is going, like the Attorney General said, that you were trying to do right by the environment. You were trying to do your part for society, and then this company goes bankrupt, and you're supposed to just keep paying on something that's not even working. That's not fair, in my opinion. We are very happy to look at your case and try to see if we can do something for you. We cannot promise results, but we can promise that we'll fight hard for you, and we've done a lot of similar solar cases and several mass arbitrations, and so give us a call and we'll take a look at your case.